I should explain something about my professional background because it matters. I am a CPA. I have been a CPA for 8 years, and for the last 4, I have specialized in forensic accounting, tracing financial transactions, identifying irregularities, reconstructing records. I do this for litigation support. I sit in conference rooms with attorneys and explain, in precise and documented detail, exactly where money went, who touched it, and when. I am very good at this. What Renee did not know, and had no reason to know because we had never been close, was that the moment she filed that challenge, she handed her case to someone who does this professionally. I started with Dr. Alan Pratt. Medical board records are public in Tennessee. His license had been suspended 4 years earlier for billing irregularities. He had not been practicing clinically since then. His declaration described reviewing comprehensive medical documentation but cited no specific records, no dates of review, no methodology. From an evidentiary standpoint, it was almost insultingly vague. I printed everything and put it in a folder. Then I looked at the medical records she had submitted. I requested the complete records through Marcus's treating physicians and compared them. Renee's submission was missing 3 documents. A neurological screening Marcus had completed voluntarily as part of his palliative care intake, a written statement from his oncologist dated 6 weeks before he died, noting his full cognitive orientation, and a recorded conversation I had on my phone with Marcus, in which he walked me through every decision in his updated will, explaining his reasoning in complete, lucid, specific detail for 37 minutes. I put those in a folder too. I did not tell anyone what I was doing. My mother-in-law, Dolores, had sided with Renee. This was not surprising. Dolores had always seen me as the woman who had taken Marcus away from the family orbit, and his death had hardened that feeling. She was not malicious. She was grieving, and needed someone to be wrong, and I was the most convenient candidate. I understood this. I did not hold it against her. But I also could not trust her. My own family was in Knoxville. My parents called every week. I told them I was handling it. I did not elaborate. The one person I told was my attorney, Patricia Odom, who had been doing probate litigation in Nashville for 22 years, with the calm, unhurried manner of someone who has seen every version of this story and knows exactly which threads to pull. When I laid out what I had found in our first meeting, she was quiet for a moment and then said with great precision, "Good, keep going." So I kept going. Renee's challenge was not just about the will. Embedded in the filing was a secondary claim related to the trust, specifically to transactions that occurred in the 6 months after Gerald's death and before Marcus died. The implication was that I had influenced Marcus to move assets in ways that benefited me and diminished Renee's eventual position. It was framed carefully. It did not accuse me directly. It used language like irregular distributions and transfers inconsistent with the trustee's obligations. This was the part that told me Renee had been planning longer than I initially thought because she was right that there had been distributions. What she did not know, could not have known because she had never asked Marcus about trust administration when he was alive, had never shown the slightest interest in the mechanics of it, was that every single transaction had a paper trail Marcus maintained with the same quiet thoroughness he brought to everything else in his life. I went through 2 years of trust records, every distribution, every transfer, every account statement. Marcus had kept a running document updated monthly, explaining each transaction, property tax payments on the Franklin house, maintenance costs, an HVAC replacement, a distribution to Renee herself, $42,000 documented for a down payment on her own home that she had never disclosed in her filing. I added that to the folder. I also found something else, something I had not been looking for. In the 8 months between Gerald's death and Marcus's diagnosis, there were 6 wire transfers from the trust account to an LLC called Harwell Property Solutions. The amounts were not large, between $8,000 and $14,000 each, totaling just under $70,000. The trust documents did not authorize payments to outside vendors without co-trustee approval, and Marcus was the sole trustee at that point because Renee had formally declined the co-trustee role when Gerald's estate was settled. I looked up Harwell Property Solutions, registered in Tennessee, filed in Davidson County. The registered agent was a man named Dennis Colley, Renee's husband's business partner. The payments had been authorized by someone with access to the trust account Marcus's login credentials specifically, except Marcus had not made those transfers, or rather had made them believing they were legitimate property management invoices routed through the trust's administrative email. I found the emails. They had been sent from an address almost identical to the property management company, differing by a single letter, the kind of thing you process on a busy morning. Without examining closely, Marcus had been defrauded. While administering his late father's estate and preparing to fight cancer, someone had used a spoofed email account to route nearly $70,000 out of his father's trust into an LLC connected to his sister's family. I sat with this for 2 days before I told Patricia. She called back within an hour of reading my summary. Her voice was even and measured, which I had come to understand meant she was processing something significant. She said, "Claire, I need you to understand that what you found changes the nature of this case substantially." She paused. "Are your source documents all verifiable?" I told her they were. Wire records, LLC registration, email headers showing the spoofed domain, and invoice files sent to Marcus. I told her I had a forensic imaging of the trust's administrative email account, which I had access to as co-administrator after Marcus's death, and that the header data was intact and traceable. Patricia said, "All right, another pause. I'm going to need all of it." The hearing was scheduled for a Thursday morning in November at the Davidson County Probate Court. Renee had brought her attorney, a man named Garrett Webb, polished, slightly aggressive, the type who impressed clients with force of presence. Dolores was there, seated behind Renee in a gray coat I remembered from Marcus's funeral. She did not look at me when I came in. I sat next to Patricia, put my portfolio on the table, and folded my hands. Renee looked confident. She had dressed carefully, tissue at the ready, when the judge, the Honorable Michael Brandt, a compact man in his mid-60s with close-cropped gray hair and an expression of permanent focused attention, came in. The room stood. She bent her head, the semblance of solemnity in her posture. Garrett Webb opened with the testamentary capacity argument, walking through the timeline of Marcus's illness, the medications he had been on, and the claim that a man in his condition could not reliably exercise independent judgment in his final weeks. It was well organized, delivered with practiced gravity. Then he introduced Dr. Pratt's declaration. Patricia stood. She did not raise her voice. She simply said, "Your Honor, before we proceed, I'd like to address the qualifications of the declarant." She handed the judge a document. Dr. Alan Pratt's Tennessee medical license had been suspended since 2021 for conduct violations. He had not held active clinical privileges since that date. No documented history of expertise in oncology, neurology, or palliative care assessment. His declaration referenced a review of medical records, but provided no methodology, no dates, no specific citations. She paused. Judge Brandt looked at the document, removed his glasses, rubbed the bridge of his nose, and replaced them. He looked at Webb. "Counsel Webb," he said, "a physician offering an opinion about a decedent's cognitive capacity in a testamentary challenge is offering expert opinion regardless of how it's labeled. Motion to exclude is granted." He set the document aside with the clear finality of someone accustomed to being precise. Webb pivoted to the trust distributions, the irregular transfers, laying out the financial argument with charts and account summaries. Patricia let him finish. Then she stood and introduced a comprehensive audit of the trust records for the period in question, handing copies to the judge, Webb, and the court reporter. I watched Webb's face as he flipped through the first few pages. Something shifted behind his eyes, the way a person looks when they realize the room is smaller than they thought. The audit was 47 pages, documented every transaction, every authorization, every distribution, including the $42,000 Renee had received for her home purchase. Included Marcus's monthly administrative notes, his oncologist statement, the neurological screening results, and at the back, in a clearly labeled appendix, the wire transfer records, the LLC registration for Harwell Property Solutions, the email header analysis showing the spoofed domain, and a timeline correlating the fraudulent invoices with the outgoing wires. Patricia walked the judge through it section by section, unhurried, thorough. The documents spoke for themselves. At page 31, covering the Harwell transfers, I heard Renee make a small, compressed intake of breath. Judge Brandt had been taking notes. He stopped, looked up at Renee's table, then at Webb. "Mr. Webb," he said, "are you aware of the transactions detailed in Appendix C?" Webb said he was not. The judge studied him. "I'd like to take a 20-minute recess." During the recess, Patricia and I sat in the hallway. She said, "You did good work." I did not respond. watching the door to the courtroom and thinking about Marcus on the back porch, the bourbon he never finished, the card he had mailed to his college roommate 2 weeks before he died because he never missed a birthday. When we returned, Webb looked different, careful, contained, as if he had just received a difficult call. Renee rigid in her chair. The judge settled, reviewed his notes and said, "Miss Whitfield's counsel has introduced evidence suggesting that funds were diverted from the Gerald Whitfield Revocable Living Trust through fraudulent invoices routed to the trustee Marcus Whitfield prior to his death. Evidence includes wire records, email header data indicating a spoofed sender domain, and an LLC registration linking the recipient entity to parties connected to the opposing claimant." He paused. "This court is referring that matter to the district attorney's office for review." Webb started to speak. Judge Brandt raised a hand slightly. Webb stopped. "On the question of testamentary capacity," the judge continued, "the court finds the claimant has not met the burden of demonstrating that Marcus Whitfield lacked the requisite capacity at the time the will was executed. The excluded declaration notwithstanding, the weight of the medical documentation entered into evidence, including a contemporaneous cognitive assessment and a treating physician's statement, supports a finding of capacity. Challenge to the will, denied. Estate proceeds in accordance with the decedent's documented wishes." Dolores drew a sharp breath behind me. I did not turn. I kept my eyes on the judge, already moving to the next folder, the next case, 40 more things on his docket. Justice pausing only to take a bow. Outside the courthouse, Patricia shook my hand and promised to follow up on next steps. I said, "Thank you," walked in opposite directions. I sat in my car for a while, long enough, then drove home to the house Marcus and I had bought together 3 years ago. Our house, the kitchen he had repainted on a long weekend, the back porch where he used to sit in summer evenings. I made coffee, stood at the window over the sink, looked out at the yard, drank it while still hot. The DA's office opened a formal inquiry into the Harwell Property Solutions transfers 4 weeks later. Dennis Colley, Renee's husband's business partner, was charged with wire fraud and theft by deception. The spoofed email domain was traced to a service registered in his name. Renee was named as a person of interest. Her husband retained separate counsel. Dr. Pratt was reported to the Tennessee Medical Board by Patricia's office and by the DA. The board opened a review of whether his participation constituted unauthorized practice of medicine given his suspended status. Existing sanctions were extended pending the outcome. Webb withdrew from representing Renee shortly after the hearing. Dolores called me in December, a Sunday late afternoon. Quiet at first, then carefully, each word chosen. She said she had not known about the transfers, believed Renee's story about protecting Marcus's legacy, and was sorry. I told her I believed her, did not think she was a bad person, and offered coffee sometime. She said she would like that. I do not know what happens next with her, whether we become something more or remain cordial strangers shaped by grief. But Marcus loved his mother, and I will give her the chance. The Franklin house, Gerald's house, the one Renee expected to claim, was sold as part of the trust distribution. My share handled by Patricia's office. I did not keep it. I donated a significant portion to the youth basketball program Marcus had coached for 4 years, which held a moment of silence for him the Saturday after he died. I still live in our house, still make coffee in the kitchen he repainted, still sit on the back porch on warm evenings, sometimes talking out loud not to the air, but to the memory of a man who was clear-headed, deliberate, who looked me in the eye and trusted me completely. I kept that trust. I played to the evidence, to what was true. When the judge set down his pen and moved to the next folder, that was enough. That was everything.